The United States of America today is the epitome of diversity. People from all walks of life and numerous cultures gather here, the world's cradle of opportunity, in order to pursue a better life for themselves and their posterity. Americans have kept their freedoms for centuries as a result of governing documents protecting their civil rights. However, there are a number of dark moments in American history where the right to equality was denied, and this was especially true in the 1950s. According to the U.S. Census Bureau, only 14% of African Americans at the time had a high school diploma. This was a result of the separate and poorly equipped institutions they were forced to attend because of the color of their skin. In the case of Brown versus Board of Education, students from 5 different instances nationwide combined to form the plaintiffs in a case that would be deemed a landmark Supreme Court decision. Brown versus Board was a turning point in U.S. history because that decision set the foundation of the judiciary holding fast to the principle of equal protection for all U.S. citizens. The road to the Brown versus Board of Education case consisted of 5 major stepping stones, the first of which was during the 19th century in what many call one of the most infamous court cases in history. Dred Scott initially went to trial in 1847, and 10 years later, after numerous appeals and reversals, his case was taken to the Supreme Court. Scott had traveled extensively with his slave owners, and one of these journeys landed him in Illinois, a free state. Therefore, Scott had the opportunity to seek freedom legally on 2 premises: the fact that Illinois was above the Mason-Dixon line, and that the Illinois Constitution of 1818 stated, "Neither slavery nor involuntary servitude shall hereafter be introduced in this state." 1 year later, he pursued freedom through the courts in June of 1847, but lost on a technicality: lack of proof of former ownership. After working his way through the state courts, Scott appealed to the Supreme Court, and there, in 1856, he encountered 9 justices with pro-slavery biases. After a decade, in March of 1857, the court unanimously ruled that because Scott was black, he was not a citizen and therefore had no rights. This was the first example of blacks' treatment as second-hand citizens. The second and most instrumental stepping stone on the road to Brown versus Board is the 14th Amendment of the Constitution. Ratified on July 9, 1868, the 14th Amendment granted citizenship to all persons born or naturalized in the United States. This included former slaves that were freed. The amendment also forbids states from denying any person life, liberty, or property without due process of law, or denying to any person within its jurisdiction the equal protection of laws. Because the 14th Amendment explicitly mentioned the role of the states, it expanded civil rights to all Americans. This amendment is cited in litigation more than any other amendment and serves as the basis of all cases related to civil rights. The next major stepping stone is the establishment of the 1887 Jim Crow laws. This racial caste system was the materialization of the Dred Scott decision, as African Americans were relegated to blatant second-hand citizenship. Operating predominantly in southern and border states, Jim Crow became more than just a set of anti-black laws. It was a way of life.
Us who were white, we missed out on understanding other people's cultures. Although a lot of us had, African American friends, but it's different if you're in the same classroom with a person. You get to know how they think and what their perspective is and that kind of thing.
The Supreme Court upheld the Jim Crow laws through the end of the 19th century. The civil rights cases of 1883 overturned the Civil Rights Act of 1875, which deprived African Americans of rights in public facilities. Supreme Court officials stated that the 14th Amendment did not give the federal government any power to stop privately owned organizations from discriminating against African Americans. In 1890, a General Assembly in the state of Louisiana passed an act that separated railway carriages for black and white passengers, Homer Plessy being one of the former. As the plaintiff, Plessy challenged the act on the premise that it violated his 14th Amendment right to the equal protection of laws. The case was eventually brought before the Supreme Court, and the court ruled that segregation was indeed legal as long as the separate facilities were equal. This separate but equal doctrine became the legal footing for segregation in the years to come, particularly in school facilities. The Plessy versus Ferguson case of 1896 was the fourth and most significant step on the road to Brown versus Board. Over the course of the next 60 years, African Americans would endure various forms of oppression. Hate crimes increased as white Americans sought to violently express their disapproval of black citizens. But the most severe form of African American persecution was segregation in the public arena. From water fountains to restaurants, and most importantly, educational facilities, black citizens were consistently reminded of their status as second-class citizens, as their separate facilities were far less than equal. Many African Americans sought to combat the inequality, and this prompted the 1909 founding of the National Association for the Advancement of Colored People, more commonly known as the NAACP. The NAACP was established in hopes of abolishing segregation and discrimination and securing more civil rights for African Americans. This was the fifth and final step on the road to the Brown versus Board case. For years, the NAACP continued to work tirelessly for the African American community and as such became a fortress of legal action. African Americans began challenging the doctrine of segregation in the 1930s through the court system, and in the following years, civil rights litigation became increasingly impactful. Oliver Brown, Topeka, Kansas native and father of then third grader Linda Brown, watched his daughter walk 1 mile every day to reach her black elementary school when there was a white elementary school 7 blocks away. Mr. Brown decided to seek the guidance of McKinley Burnett, the head of Topeka's branch of the NAACP. Burnett then took the case to NAACP headquarters, to civil rights champion Charles Hamilton Houston. Houston implemented the equalization strategy, in which lawsuits were filed demanding that black educational facilities be made equal to those provided for white students.
Well, Brown versus Board of Education was needed. There needed to be some type of ruling, and it started with the courts and then went into the legislature from there. It was necessary. That was the only way it was going to get done. And again, the NAACP and Dr. Martin Luther King's group that organized and brought these lawsuits, it needed to be done.
The Supreme Court first heard the case on December 9th, 1952, but failed to reach a consensus. The re-argument was heard December 7th and 8th of 1953, and the court asked both sides to examine the context in which the 14th Amendment was established in 1868. This offered minimal assistance and ultimately left the decision in the hands of the justices. On May 17, 1954, Chief Justice Earl Warren read the unanimous decision.
We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we unanimously hold that the plaintiffs are deprived of the equal protection laws guaranteed by the 14th Amendment.
With this decision, the Supreme Court struck down the separate but equal doctrine of Plessy versus Ferguson in public education, bringing an end to segregation in schools across the United States. Brown decision became a major part of the foundation of the social justice movement of the 1950s and 1960s. Almost 60 years later, children of all ethnic backgrounds can go to school with the assurance that the opportunity available to them is equal to that of their counterparts. Minority students now know that they will receive equal protection of their rights, not because they are deprived, but because they are citizens of the United States of America. As such, students of all creeds know that the land of opportunity is theirs for the taking.